So a new case is seeking Supreme Court review because the Second Circuit has refused to follow the Supreme Court's unanimous decision, which found that the warrantless search and seizure of firearms is unconstitutional. So let's talk about this. But real quick before we jump into this video, if you agree that police should not be able to unlawfully search and seize firearms without a warrant, go ahead and hit that like button and subscribe. Also, I want to thank one of the main sponsors of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, a new case is now seeking Supreme Court review, and this case deals with the unlawful search and seizure of firearms by police without a warrant. The case we'll be talking about in this video is Torcivia v. Suffolk County. This case involves the use of the special needs exception to the warrant requirement to confiscate firearms based on a single call that a grandfather was acting irrational. This case is similar in nature to another Supreme Court decision we have talked about before on the channel, which is the Caniglia v. Strom case. This case, Torcivia, is a lower court decision that flies in the face of that prior Supreme Court decision, stating that permitless and warrantless entry of a home under the community caretaking exception is unconstitutional. So the facts surrounding this case, Torcivia, are really interesting. Mr. Torcivia is a 57-year-old man who has no record of violence and no history of suicide attempts, depression, or any mental health treatment. Early in the morning of April 6, 2014, his teenage daughter called social services, complaining that her father was yelling at her and acting weird. Now, at no point during this call or any point after did she ever claim that he had assaulted her or that he used a firearm or displayed a firearm. No firearm was even mentioned at all during this incident. Now, after that call from the daughter, social services contacted the Suffolk County Police Department and they dispatched 3 officers. Each officer arrived at the house, and on contact with Mr. Torcivia, they agreed that he had committed no violation of law, that the daughter's complaint was completely unsubstantiated, and that there really was no issue. However, at one point during the discussion between Mr. Torcivia and the police officers, one of the police officers slightly turned and accidentally dislodged a magnetic drape which was attached to the front door. Then Mr. Torcivia bent down, I guess, to pick it up, and the officer then screamed at him very loudly and said that he needed to get back, and also the police officer threatened to tase him. Now, in the lawsuit, Mr. Torcivia claims that he told the police officer not to tase him because he has a heart condition and that it could kill him. Now, the police officer claims in the lawsuit that he understood the statement by Mr. Torcivia that he wanted to be tased and that he wanted to die. In reaction to this, they then handcuffed Mr. Torcivia and transported him to the Stony Brook Hospital's Comprehensive Psychiatric Evaluation Program, or CPEP, for an emergency mental health evaluation. Now, without asking whether the Torcivia family had any firearms in the home, each of the officers left the home, and they transported him again to that hospital. Only after dropping him off for a psych evaluation did one of the officers learn via a computer check that he had a New York State pistol license and therefore had firearms in the home. The police officer then contacted his sergeant, who instructed him to ask Mrs. Torcivia, his wife, for the guns, and if unsuccessful, to return to the hospital to get consent from Mr. Torcivia to seize the firearms. However, both Mr. and Mrs. Torcivia denied consent to seize the firearms. Now, eventually his psych evaluation came back clear, and 12 hours later, he was recommended to be discharged. He then was discharged with no condition that he be released only if he had his firearms surrendered. So there was no condition on his release. However, that social worker who was on the case told her intern to get the combination of the gun safe from the wife. And if she couldn't get it from the wife, she should go to Mr. Torcivia and also try to get the gun combination for the safe. The social service worker intern also then called Mr. Torcivia and told him he would not be released until the firearms were confiscated and that police were on their way to his home to get the weapons. Well, Mr. Torcivia initially refused once again to give up the combination to the safe, refused to give up his firearms, but eventually he gave to pressure and did give the combination to his wife, and the wife then gave over the handguns and also long guns to the police when they arrived to the house. But again, even when the police arrived to the house, they did not have a warrant. Now, after this whole incident, Mr. Torcivia also did try to get his firearms back. On May 6, 2014, he requested the return of all of his firearms from the police. His pistol license, however, was later revoked, and although there was a hearing over the loss of his license in late 2015, he never did recover his handguns. And it took almost 2 years for the department to even release his long guns to a store who then could transfer them to him. So it took him 2 years to even get his long guns, but even still now, he does not have his handguns. This case made its way up to the Second Circuit for review, and on review, the Second Circuit found that under the special needs exception to the warrant requirement, the police were able to do this to him. In reaching their ruling, the Second Circuit largely ignored the Supreme Court's ruling in Coniglia and left only one single mention to it in a footnote. The Court of Appeal simply asserted that the special needs exception is different from the community caretaking exception at issue in Caniglia. Think about how the state of New York has the proper cause standard for CCWs and how it's similar to the California good cause standard for CCWs. They may use different names, but they operate in the same way. But essentially here the Second Circuit is saying no, they have different names, so Caniglia doesn't apply. Now, if you're not aware, last year the Supreme Court issued a ruling in a case called Caniglia v. Strom. That case dealt with whether the community caretaking exception that applied to vehicles could then be extended to warrantless search of homes. In 1973, the Supreme Court decided a case called Katie v. Dombrowski. In that case, the Supreme Court held that the police officers had not violated the Fourth Amendment by searching without a warrant the trunk of a car that was towed after an accident for a firearm because it was part of the officer's community caretaking functions. Therefore, a warrantless search of an automobile could be constitutional. But Katie was largely based on the difference between automobiles and homes. However, in the Caniglia case, the First Circuit Court of Appeals held that the community caretaking exception to the warrant requirement could also apply beyond vehicles and could apply to searches of the home as well. That case, Caniglia, made its way up to the Supreme Court, and the court issued a unanimous decision in favor of Mr. Caniglia. Justice Thomas, writing for the majority, stated in his opinion that the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his home and there be free from unreasonable governmental intrusions. Justice Thomas therefore found what is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledged as much, and this court has repeatedly declined to expand the scope of the exceptions to the warrant requirement to permitless, warrantless entry into a home. So in this case, Torcivia, the petitioners seek a summary reversal by the Supreme Court based on the Second Circuit's outright refusal to apply Caniglia. They state in their petition, as in Caniglia, there was no dispute that the exigent circumstances exception did not apply. Indeed, they state this case is even clearer than Caniglia, as the officers, under the facts assumed below, concluded that the initial complaint that brought them to the petitioner's home was groundless, and because there was no history of mental illness or suicide, or violent thoughts or conduct. And they state that the Second Circuit's efforts to distinguish Caniglia from this case is the plainest of plain errors, if not an outright resistance of the court's authority. Because of the direct violation of the Supreme Court's precedent, they request that the court issue a summary reversal, which is a harsh remedy available to the Supreme Court that they often will only use if a lower court, like the Second Circuit, refuses to adhere to the Supreme Court's precedent. So that is one ability the Supreme Court has. They can issue a summary reversal. They can say, we don't want briefing. We don't need to further argue this case. Lower court, you are so clearly incorrect that we are just going to issue a summary reversal of your decision. And that is what's being requested here in this petition. However, they also argue even if the Supreme Court believes summary reversal is not appropriate, it should still grant review of this case because clearly there is still a conflict between circuit courts on warrantless search and seizures under these types of exceptions. Also in the petition, there's a request for a review on the question of if a non-police employee like those healthcare officials involved in this case should be entitled qualified immunity or should they not be. So again, there was the social workers and the intern involved in this case. And the question is, what type of protection should they have from lawsuits? Should they be granted qualified immunity like police officers? Or do they not have qualified immunity? So this is an interesting case we'll be keeping our eyes on, and I'm interested to see if the Supreme Court takes this case up next term and continues to issue pro-freedom decisions. This, again, is an interesting case. This shouldn't even be an issue. This should have been addressed by Coniglia, but as we know, lower courts like the Ninth Circuit and the Second Circuit like to directly refuse the Supreme Court's rulings, and it actually takes the Supreme Court directly addressing them saying, no, you need to stop doing this before they ever stop actually doing it. So if you guys have any questions, go ahead and comment down below and I'll try to answer them to my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this is built by armed scholars, and this nation will be maintained by armed scholars.